All right, this is 2509380M, the People versus Randall Crane. Are we ready on Randall Crane? Mr. Crane's coming up. Hey, you, Mr. Kazicki?
No.
Mr. Crane, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barrett, I did speak with Mr. Crane prior to the court calling the case today. I think that at this time, Mr. Crane's probably best served proceeding on his own. There are some constitutional arguments that he's raising that I don't think as a member of the bar I can.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for that. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crane. That's a living name, not a corporate fiction.
So you're a real person named Randall Crane.
Person. Okay.
Okay, no, listen to me. Sir, you're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction to the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
you have to provide subject matter jurisdiction as well as personal jurisdiction to me before.
This is it, People v. Randall Crane. From the very first words, we know it's not going to be a normal day in court. The judge is calm, professional, ready to handle business. But then comes Randall. He's not here to face charges like everyone else. No, Randall's about to bring in a script he learned off YouTube University. He thinks the courtroom is a stage, and he's the lead actor in a sovereign citizen play. But this isn't entertainment. This is real court, and Judge he doesn't play games.
Jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right. So, sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
my notes are on.
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here and say them, I can tell you can't have a court. I can tell you can't have a phone in here.
Judge Shackelford lays down.
Here we go. The Sovereign Citizen Handbook comes out. Living man, not a corporate fiction. Randall's convinced that by reciting magic words, the charges vanish. But judges, they've heard this 1,000 times. Shackelford doesn't. Blink. He's not explaining, not debating. He's shutting it down. Jurisdiction, already established. Sovereign theories, nonsense. And Randall doesn't realize it yet. But every word he adds only digs the hole deeper. You don't win in court by out-talking the judge. You win by having facts and law on your side. Randall has neither.
You're here today on misdemeanor charges. No talking. You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in the while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device, first offense while operating a motor vehicle, a charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pretrial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pretrial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial. Okay, those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney.
And here's the reality check. The judge lays it out plain: misdemeanors, civil infractions, and possible jail time. Randall wants to play courtroom fantasy football, but these are real charges with real consequences. 90 days in jail, hundreds in fines, insurance, registration, all the boring but very real legal requirements of driving. But instead of addressing those, Randall keeps swinging at invisible dragons called jurisdiction. The judge is basically spelling it out for him. This isn't about your YouTube theories. This is about your freedom. And the clock is ticking.
Make the frivolous arguments you're making on your behalf, or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those four options what you want to do. Hire an attorney, speak with court appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir,
exactly
here,
what-
can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your
Your
case
Honor,
back up.
I am asking for you.
Have a seat right now
What
and
was
read your
oath of
rights.
Office.
I see contempt in his future.
Have a seat.
Have a seat right now and read your rights, sir. If you
I
don't
read-
understand them, read them.
I move for this court to dismiss.
Have a seat.
Where is he? Okay, well, that might never happen, but, what was that guy's name on that file? Because I'm assuming did he leave?
Cream. He did.
Did he leave?
Randall
Well,
Cream.
he's big mad. Well, I need that file, so I'm gonna give him a bench warrant. All right. All right. Are you okay, Amy?
Yeah.
I'm coming. I promise I'll get to you real.
RFK Jr. is correct. Fluoride in water has hardened a lot of brains.
I'm just, you know what? I know I should be more patient. I'm so tired of the sovereign citizen. All right, we're coming back up. This is 2509380M, the city of Taylor versus Randall Crane. Mr. Crane, you want to come back up? Mr. Crane, did you have a chance to go over your constitutional rights that I provided to you?
Yes, I understand my constitutional rights.
Okay, thank you, sir. So at this time, I gave you four options. Would you like to retain your own attorney? Would you like to speak with House counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Or would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else? There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney,
I understand
a
that,
court-appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain Listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the 4 choices I gave you, which one would you like to do?
I am required to understand everything in regards to my case,
Okay.
including subject jurisdiction matters.
All right, well, you could do your
Personal
research. I'm
jurisdiction.
setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do, waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in, you're going to try your case. Again, if you want to talk to House Counsel, you could do so. All
I'm
right.
not wasting the city of Taylor's time.
Okay, good.
Now this part, this is critical. Judge Shackelford actually takes the time to read Randall his real rights, not TikTok rights, not strawman corporate fiction rights, actual US constitutional protections, right to counsel, right to trial, right to remain silent. This is the system giving Randall every tool to defend himself. But instead of listening, he's still hung up on imaginary loopholes. It's like being handed body armor before a battle and saying, no thanks, I'll use this cardboard shield instead. And the frustration on the bench, you can hear it rising.
What is your name?
I'm Jonathan Wiggins.
Okay. Your ticket is 25RO03001. This is a speeding ticket that was issued on the 9th of May at about 1:30 in the morning. You're eastbound 11 Mile in Lafayette. You were cited 35 and a 30. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Not guilty.
Raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
Okay. The officer will testify first, please.
Your Honor, on the listed date and time, I was traveling eastbound on 11 Mile approaching Lafayette when I observed a black 2021 GMC Yukon traveling westbound on 11 Mile, eastbound on 11 Mile when I activated my front moving opposite radar and got a reading at a 47 miles per hour in a 35 mile per hour zone. I also observed the vehicle moving at a very high rate of speed, and that's when I activated my radar. The radar was tested before and after my shift, and I am certified to operate radar, Your Honor.
Thank you. Mr. Wiggins? Sir?
You want to hear my statement is what you say?
Yes.
Okay. I'm Jonathan Wiggins. I was coming home from work, 1:30. I take that route.
We've lost sound.
No, he froze.
He froze and we lost sound.
Let's see if I can go.
Do we have a phone number?
We do.
Your Honor, I'd like to just clarify something. I was traveling, I might have missaid something in my testimony, but I was traveling westbound. The vehicle was traveling eastbound on 11.
I don't know what happened, but it just cut off on me.
Yeah, but we got you back.
Okay.
So where it left off was you said you were on your way home from work?
Yeah, I get off at 1:15 and I take 11 Mile every day. And I know to do 35 miles an hour on 11 Mile Road and 45 miles an hour on Woodward. I don't have no reason to be racing up and down the street. I'm 60 years old. It was a car on the side of me when he was in front of us, facing us. And when he pulled me over, he said, "You know, you pulled me over for." I say, "No, I don't." He was like, "Well, you were speeding." And I was like, "Well, it was two cars. We were side by side on the lane. So how was I speeding?" And he said, "I visually radared you at 47." And I said, "Excuse me?" And at first, he didn't have a radar. When I read my ticket, it says that he used a radar. And then he said, "Well, I'm just going to give you a ticket for 1 to 5 over." I still take this route every day. I'm tiptoeing just to get to 75 so that I can get home. It's kids racing up and down Woodward and all type of sports cars. I'm not one of those. And I didn't like him saying that I was speeding.
And here's where patience runs out. The judge has explained, instructed, and repeated. Randall still refuses to pick an option, still insists on playing professor of fake law. Finally, Shackelford shuts it down. Sit down, read your rights. We'll call you back. That's judge speak for, you're out of chances. And when Randall tries to leave, big mistake. Walking out on a judge is like slamming the door in a cop's face. It doesn't end well. And Shackelford's already moving toward the nuclear option, a bench warrant.
It's going to be pretty darn close. Research indicates that the visual observation speed, not with a radar, but made by an officer, is going to be about 2 miles an hour slower than the car is actually going. But the point is, the officer thought you were speeding. He didn't cite you for what he thought you were going. He operated the radar so as to measure the speed, and he found that you're going 47. You've got a decent driving record, to say the least, and in the exercise of his discretion, he elected not to cite you for the full 3-point infraction, but he gave you a 1-point infraction. He knocked it down to a 1-point event. He's certified to operate radar. The radar unit was checked both before and after his shift. It worked at the start. It was still working at the end of his shift. It didn't break and fix itself some point in the middle. So there's no finding here that says that you were intentionally speeding, but I do believe you were going 47, and that means at least 35. So I do think you're responsible for 35 and 30. That is the speed limit there, 30 miles an hour.
Yes.
And the fine for that is $130. The $130 can be paid online or by mail, or you can pay it at the courthouse counter if you prefer.
Can I eliminate the points, Your Honor?
The points don't come from the court. They come from the Secretary of State. I can't change them.
And you say he checked his radar, not you, right?
Of course, I didn't check his radar.
Okay.
I don't know anything about radar.
He didn't have a radar, sir.
Yeah, he did.
He didn't use. He told me he did not use a radar. It was.
Oh, that's not what he said. He said he made a visual observation of the fact that you were speeding.
It was two cars. It was both of us. It was two cars.
That doesn't mean that either one wasn't speeding. If two cars are going the same speed, that means they're both going the same speed.
Yeah, so pull both of us over.
That's not practical.
Yeah, it is. I don't understand. I just know. You know what I really believe?
I don't think I want to hear.
He got a chance to judge, and that's all I can say.
As he's driving in the opposite direction from you, he has no idea as to how many people are in a car or what they.
Randall comes back, but nothing has changed. He still wants a change of venue, denied instantly. Still wants to debate jurisdiction, denied again. The judge isn't even entertaining it anymore. He's done arguing with nonsense. Instead, he makes the decision for Randall. This case is going to trial. No more delays. November 14th, 2025. Be there. And the judge even gives him one last lifeline. Hire a real attorney. But Randall doesn't want lifelines. He wants loopholes. And by rejecting reality, he's basically volunteering to lose.
Who's ready? Anybody here for Jeff Hodges?
Yes, I'm here.
All right, I do see you now, Mr. Hodges. Thank you very much. This is a motion for summary disposition filed by the defense. I'm going to give each side an opportunity to tell me why they believe that their side should win. Counsel, go ahead.
Your Honor, just so I can clarify, I think today, I'm happy to go forward. We did file, Ms. Sheldon filed a motion for summary disposition. It is set for hearing July 14th, just to comply with the court rules, the 21 days. This was the date and time set for a pretrial. Again, happy to go forward with arguing the motion for summary disposition, but per the court rules, we had to set the hearing out 21 days.
I see that now. Thank you for bringing that to my attention. Mr. Hodges, did you understand what he just said?
I don't know the procedure.
The procedure is if they file a motion such as he's filed called a motion for summary disposition, that is a motion that says we win by virtue of what the law says. They have to give you 21 days to respond to that. And that would be on July 14th. It's already set for a hearing then. So 2 weeks from now. However, if you want to, you could allow that to be heard today and we would just cancel the hearing on July the 14th. If not, we'll probably just come back on July the 14th and we'll argue it then. What would you like to do, today or on July 14th?
I prefer to see what can be solved or not solved today.
Okay, so you want to go forward today and not have the hearing on the 14th, is that correct?
Yes.
Okay, all right. So I'm going to give both of you again an opportunity to argue your sides and to put out whatever information you want me to have. So counsel, this is your opportunity. Go ahead.
Yeah, thank you, Your Honor. This is, I trust that the court received the briefs and the motion. This is one of several actions filed by Mr. Hodges in the wake of his termination as a contract worker, ultimately for the end client, Wade Trim, Inc., which is a professional engineering firm. Mr. Hodges filed several actions that we believe are frivolous. This is one against Mrs. Sheldon, who was a remote supervisor of Mr. Hodges during his 3 or so weeks as a contract worker. Mr. Hodges was terminated for performance purposes, performance concerns. He was an at-will employee. He was actually terminated from it's called Act Talent, which is a staffing agency that Wade Trim uses to staff some of its engineering projects. This was filed initially as a small claims matter. There's a short affidavit with half a paragraph or so of allegations that are vague, conclusory, do not state a cause of action, and do not state any facts that would support any cause of action under Michigan law. So Ms. Sheldon moves under MCR 2.116C8 and 10. There's